Okay, next, let me just quickly outline the various steps in the bankruptcy process because a couple of these steps are really important for landlords. And I personally, thank God, I've never filed for bankruptcy. Hopefully, I never will. I had no idea, what the different steps are other than on vague terms. But as I mentioned, I'm just going to quickly go through it because there's a couple steps that are really important for us landlords. Okay, so the first two steps don't necessarily have to go in this order, but they're going to be very, very close within each other. And I think what a lot of people do is maybe I should have put a first step here, like Hadi was saying, is the first step is that's it. You reach your limit. You, for whatever reason, you decided I just can't take it anymore. I'm getting all these phone calls. My car got repossessed. Whatever it is, you reach your limit, and then you decide to do something about it. A lot of people, what their first step is they do hire an attorney because they just don't know how to navigate the process. They don't know what paperwork's involved. They just don't know what to do. So it's better to get, advice from an attorney. So some individuals, you can go through the bankruptcy process on your own, but most people do hire an attorney. It's pretty complex, all the different laws. There's different types of bankruptcies. There's a ton of forms to fill out. And most people just don't have the experience or knowledge to navigate that on their own. So they do hire an attorney. And then also, it's sort of like the eviction process. Can you file for evictions on your own as a landlord? Sure, you can. But you need to navigate everything, figure everything out for yourself. And then number two, if you do something wrong, just like eviction, your tenant's going to stay or you got to start all over again. The bankruptcy can be denied, your assets get seized, etc. So again, like evictions, it's sometimes there are circumstances where it's just better to hire an attorney, and I think that's what most tenants do. Shortly thereafter, or maybe even sometimes before, what the individuals are going to have to do is pull together all their financial information. So they got to make a list of their debts, their expenses, their income, and their assets, and they got to pull together, all of their documents, their tax returns, pay stubs, bank statements, etc. Okay. Um, I didn't know this, but the next step is that individuals, before they file for bankruptcy, have mandatory credit counseling, and they have to undergo that within 100 days before they file. And they just can't choose anybody. I guess there's this list of approved counseling agencies listed on the website. And what these agencies do is they go through I forgot a word here, the pros and cons of bankruptcy. And they say, hey, instead of filing for bankruptcy, this is what you should do, et cetera, et cetera. After the individual goes through the bankruptcy, they get this certificate and they have to prove to the court that they went through this credit counseling by providing them a certificate. I'm not going to go any more detail of this because it doesn't pertain to landlords. But the next step then is finally individual gets to file what is called a petition for bankruptcy. This is where the individual either the individual or their attorney fills out and submits the forms to the United States court system. And this is why it was recommended that attorneys fill this out. There are 20 different forms, 70 total pages that have to be filled out, which is beyond most people. And this is important for landlords. At this point, when the bankruptcy is filed with the court system, it starts the bankruptcy process and it now appears on the credit report. So sometimes, it's important for us to take a look at when we're pulling the credit report to understand when does the bankruptcy appear. It's when the person actually files the bankruptcy petition. So they're sort of serious about going through here with the bankruptcy. Okay, so we'll return later on in the presentation to the specifics about how the bankruptcies look on the credit report. Now, this I learned because I didn't know this until I did the research for this presentation. Once somebody files a petition with the court for the bankruptcy, it triggers what's called an automatic stay. This is a legal term. And what happens during automatic stay is that the creditors are notified that somebody has filed for the bankruptcy. And this is the important part. Creditors can no longer go after them for their debts. So this is when the phone calls stop, they stop receiving the letters, and any legal proceedings that have been going on at this point need to be stopped. So the lenders has to stop the foreclosure process. Your car can't be repoed anymore. People can't file liens, etc. Again, we're going to return to this here later on because this part is important for landlords. There's something that we have to do when the automatic stay starts here. After that automatic stay gets instituted, and this will take place until the case gets resolved. So it can take 2, 3, 4, 5, 6 months, and nothing, including us landlords, are going to be able to do anything about some of these debts. During this time when the bankruptcy is proceeding through the courts, a trustee is appointed there. The individual who's filing the bankruptcy has to submit all of this paperwork to substantiate, why they're filing, etc. And now at this point, the person has to take more classes. They call it a financial management course or a debtor education course. And at this point, the person learns how to make a budget and how to avoid debt. I always find it fascinating that, these are not taught in school, either, high school or college. And that's what gets a lot of people into trouble. But I guess better late than never at this point. Some, people who file for bankruptcy do need to take some classes here. And then I'm not going to go into these anymore because again, these don't affect landlords, but this one will affect us landlords. Once everything has been finished, the trustee gets all the documents from the individual. They set up a meeting with the creditors. It's called a 341 meeting. So at this point, anybody who is owed money, we have to give them evidence that somebody owes us that money. And then the people who are owed the money, the creditors can question the person, say, and ask them, they can challenge what this debt is all about. So again, we'll get back to this when it pertains to landlords. And then that's it. At that point, the judge makes a ruling once they review all of the documents. And there are two outcomes. The bankruptcy can be discharged. So that's it. Bankruptcy is done. It is determined that the person is no longer responsible for their debts. They may or may not have to pay back some of their debts, and it depends on the type of bankruptcy. And we'll get to that next, the two different types of bankruptcies. Or the bankruptcy can be dismissed, in which the individual is still responsible for paying their debts. So I know that was a lot of information, and we'll get back to it in more detail when we get to each of these steps. But just remember, automatic stay, that stops the whole entire bankruptcy process. And then discharge is important. That means the case is done. And, the applicant, yes, they have a bankruptcy on their record, but that's it. They know where they stand. They know how much money they have to pay. They know what their monthly payment is going to be. And it's a very clear-cut case for us landlords to be able to judge the applicant if they have a bankruptcy. Okay. Let me go through the different types of bankruptcies, because again, that's going to have an impact on when we are taking a look at the bankruptcies, whether we're going to rent to them or not. Bankruptcies are governed by the federal courts. I didn't realize this. So it's governed by what's called by the United States Bankruptcy Code. There's 6 different types of bankruptcies, but really 3 are the most commonly ones used for individuals and businesses. And really there's only 2. Chapter 7 and Chapter 13 are the ones that are going to concern us as landlords, although there is a one that might, under circumstances, called a Chapter 11. And again, we're just going to really quickly go over the different types of bankruptcies, the 7 and the 13, because it's important for us to understand these types, because it could have an impact on whether you want to decide to rent to an applicant or not, depending on the type. Chapter 7 bankruptcy is called the straight bankruptcy or the liquidation bankruptcy. So if you sometimes you see these terms, you're going to know that this is the type of bankruptcy. And this by far is the most common type of bankruptcy that people file for. And probably every single one of your tenants, if they do file, or applicants are going to be filing for Chapter 7 bankruptcy, because this is used by individuals who don't earn a lot of money and they don't have many assets to be seized. And the way that Chapter 7 bankruptcy works is used for unsecured debt. Remember, unsecured debt, or maybe not remember if you don't know what unsecured debt is. Unsecured debt is something that it's not tied to anything. It's not tied to a car or a house or something that can be seized in order to repay the debt. So here are just some examples of some of the unsecured debt. And if you remember, take a look at some of your tenants, or think about some of your tenants. I mean, they don't own houses. That's why they're renting from you. Yes, they own cars, but they're not worth a lot of money. And most of your tenants are going to have this type of unsecured debt. And what happens during the Chapter 7 bankruptcy process is that the courts basically can seize your personal property. Then the trustee is basically going to sell off the property, and the proceeds go to the creditors to pay the debt. So that's why individuals have to turn in all of the documents saying, okay, this is what I own. This is how much money I have in my bank account, etc. Then the trustee has to make decisions on whether they're going to seize those assets, whether they're going to sell them off, and they're going to use them to pay everybody off. I think this is going to be a lot of terms here. Maybe we'll skip this, but just when the trustee is looking at everything that the person owns, there are some things that are called exempt. They're not going to be sold to pay off the debt because they're considered necessary things like cars, retirement, personal property, jewelry, tools, and books, etc. And because of this, most tenants fall into this category. Most tenants are not going to have anything sold off. They're just going to go through the bankruptcy process. Nothing is going to be seized. Their creditors are not going to receive any money. Everything's going to be cleared, and they're just going to move on. But there are some individuals who do have assets that are worth money. Maybe they have family heirlooms that are worth money, or they have cash, bank accounts, stocks and bonds, second vehicle, etc. Those will be seized. Those will be appraised and sold off. And then this does apply to us because only your primary residence is exempt, and only then up to a certain amount. But second homes are not. They're going to be sold. So us landlords, if you file for bankruptcy, all of your rental properties are absolutely going to be taken into consideration and valued by the bank and everything to make a decision whether they're going to be sold off and everything. Hold on, I think somebody has their microphone open. I don't see them. Okay, hopefully they don't. All right, I know that was a lot of terms here, but just remember in Chapter 7 bankruptcy that you turn all in your financial documents. The trustee from the court is going to take a look at everything and make a decision whether you can file for bankruptcy and whether you're going to have to pay everybody back or not. So that's the nice thing about the Chapter 7 bankruptcy, and that's why people do it. All debts are wiped out, so they don't have to be repaid, except for these items here. These are never exempt from any type of bankruptcy. So sort of take that in consideration. If you do see somebody who has a bankruptcy that appears on their credit report, they still do have to pay these types of debts. So again, just to wrap up here, for landlords, remember that most tenants are the ones that are going to file for Chapter 7. And this is good for us because I guess good in that the tenants are going to have all their debts rates. So if they have fallen behind on their credit card payments, the cars, etc., they're not going to have to pay any of those, not going to have to pay anything back. And then also remember that the Chapter 7 bankruptcy stays on their credit report for 10 years.